Unless
Well, good afternoon, everyone. We are really excited that you're able to join us for what we hope will prove and what we think will prove to be a very exciting program on the Texas 2023 legislative session and what we've got in front of us. Our two presenters are Professor Richard Carlson and pinch hitting for Rick Levy. We're very fortunate to get Luis Figueroa. Rick Levy, unfortunately, COVID has decreased, but it's not gone from our lives, and he just came down with it and is unable to speak. I'm sure that a lot of management advocates on the other side of the docket are happy that he might be quiet for a little while, but we wish him well in getting better quickly. A little background on our two presenters. Professor Richard Carlson, a lot of you will know and recognize. He's presented in the past for our organization. He's a professor of law at South Texas College of Law, and he specializes in labor and employment law, employment discrimination, and family law. He teaches and writes a lot in the fields of employment law, including discrimination, collective bargaining, also family law and contracts. He's the author of a case book called Employment Law, which is now in its 5th edition. He's also the author and editor of 2 annually updated and annotated statutory compilations, Carlson's Federal Employment Laws Annotated, and Carlson's Texas Employment Laws annotated, both published by the West Group. And as if he doesn't have enough on his plate already, as most of the lawyers on this call who are from Texas know, he's also the Secretary of the Labor and Employment Section of the State Bar of Texas and the longtime editor of its newsletter. We welcome Professor Carlson and thank him for being willing to participate again today. Luis Figueroa is the Chief of Legislative Affairs for Every Texan, the group Every Texan, where he joined in 2018 as its first legislative and policy director. He oversees Every Texan's comprehensive legislative strategy. He was previously general counsel for the Texas State Senator Jose Rodriguez and executive director of the Texas State Hispanic Caucus. Previously, he served as the legislative attorney for the Mexican-American Legal Defense and Education Fund, MELDEF. We all know that group, where he worked from 2004 to 2013. He is a proud Texan and proudly from El Paso. He's received MELDEF's 2013 Award for Services Performed on behalf of the Latino community in pursuit of social justice, the 2011 Champion of Equality and Justice Award from LULAC, and the 2009 Spirit of Change Award by State Representative Joaquin Castro, among other honors. He has his Bachelor of Arts in Political Science from Trinity in San Antonio, and his JD degree from the University of Texas School of Law, and is licensed to practice here in Texas. So we welcome our speakers, and we are now going to begin our program. Luis has agreed to start off. He's going to give us sort of a general background and overview of the legislative process in the legislature this past session. Luis, you're on.
You got it. Thank you, Chip, and thank you, Professor Carlson. I'm doing my best to fill in the shoes of Rick Levy. He is a mentor, a friend. He's our board member, someone I've worked with over the years. And I was saying, he has such a specialty of knowledge in the area of labor law in so many areas. So I'm a little bit more of a generalist, but I'm going to do my best to fill his shoes. We definitely have been very involved in a lot of in the trenches of the Capitol in numerous sessions, particularly this one. We spent a lot of time working on the issue of preemption, which is a tactic nationwide that we have seen here in Texas and particularly in Florida, really aimed at curbing the authority of cities and counties to be able to enact legislation, taking away their local authority and putting it back in the hands of the legislature and really controlling what cities and counties can do. So that was the big fight this session. But just a big overview of the legislative session for those of you that aren't familiar with it. It only runs every other year. There's quite a few special sessions that the governor can call for 30 days. But for the most part, it all happens in the 140 days from January to May. The first couple of months are pretty ceremonious and a lot of bills are being filed, but not a lot of bills are moving. And then in March, we get real busy. We start having hearings. we start having legislation heard. And thankfully in Texas, they have a pretty robust system for participation in terms of they have both invited and public testimony on every bill. There were more bills filed this session than pretty much I think in the history of the legislature, but particularly in the most recent legislation. So there were a lot of bills filed this session. Some of them are duplicative, some of them are new. And then we got into April, and April is the busiest time of session. At that time, we have hearings that are starting in the mornings. The members go to the floor for 5 to 6 hours to debate the bills that have gotten out of committee. And then they go back to their committee hearings and sometimes continue all the way up into the middle of the night to finish up their hearings. And we start the process all over again. May is actually the time when it is not as busy, but the stakes are way higher. A lot of bills start to die on the deadlines. And that is when we have the opportunity to really focus in on legislation that's moving. And that's when most of the bills die. I'll just end with, it was great to see after the pandemic to have a session where there was more public participation. The pandemic session in 2021 really was a stress test on democracy. There were not a lot of non-corporate lobbyists at the Capitol. It was only the paid lobbyists that were there. And so this time we had a pretty robust session. I will say Chairman Burrows used the system to his advantage to pass what we will talk a little bit later about called the Death Star Bill, HB 2127, because he is the chair of calendars. And that is the committee that determines which bills come to the floor and which bills don't. And he used that masterfully to enact some pretty broad sweeping preemption bills. So with that, I'll turn it over back to our host and to Richard so we can get the conversation started. But hopefully that was a little broad overview of the process.
Professor, thank you, Luis. Professor Carlson, do you want to talk a little bit about what legislation did pass this legislature that impacts the employment landscape in the state of Texas?
Yeah, there's probably by my count, close to 10 different laws that might be worth talking about here. Of course, the Death Star, I think, is high on everybody's list of things that are important that happened. So I'll start there and work my way down. And if Luis has any comments that he wants to add, there's a lot to think about and to say about a lot of these laws. And I'm sure that if there's anything that Luis wants to add, just interrupt, okay?
Sounds good. Thank you, Professor.
So let's talk about this preemption law. At this point, I'm wondering if it's more symbolic than important as a practical matter. And I say that because there's a limit to what local government can do when it comes to regulating employment law. One is the natural limit that if you impose burdens on employers, they just move across the county line. You know, if the city of Houston adopts a fair wage law or a break law, it's one more reason that people end up opening up their shop in the Woodlands rather than Houston. So that in and of itself restrains, how far that you can go. So a statewide law is always better. And I understand why it is that a lot of local governments became a little more aggressive in trying to get into employment law policy, whether it's not in Texas, but elsewhere, a living wage, whether it's a break for water when the temperature is 105 degrees, whether we need a sick leave policy. All of these things are desirable. And I think there's just a lot of frustration with the fact that both Congress and the state legislatures are frequently dysfunctional. They just can't do anything. So it would be better if we could do things at the state level. There's a limit to what the local governments could do anyway. Couple of thoughts about that. Number one, maybe this is a good occasion to thinking about how you present some of these arguments at the state level. Let's talk about a minimum wage update here. Minimum wage hasn't been updated even at the federal level in, I think, decades now. Is there anybody out there who earns $7.25 an hour? I can't find such people. I try to do an update of my labor law statistics, labor economic statistics every year, and 725 is just not something that people work for. Would there be any harm in raising the minimum wage if people are earning more than that anyway? And there are a couple of responses to that. First of all, I think people are too focused on the idea that somehow we're raising people's wages generally when we raise the minimum wage. That's not the only function of the minimum wage. And in the debate between both sides here, people forget what the other important function is and the function that we ought to be focusing on. And that is the prevention of wage theft. The difficulty is that a lot of people, especially at the low wage end, are frequently faced by ridiculous deductions and credits against their wage, which reduces their pay, sometimes even below $7.25 an hour. When you have a minimum wage, it's a statement that the employer has to be paying that amount free and clear every single week. So if the employer wants to take some random deduction from the employee's wages, the employer can't do that in a way that reduces pay below the minimum wage. And I think that's perhaps the debate that we perhaps need to be having, perhaps to overcome this gridlock about the minimum wage. It's not just about what is a fair wage, it's about getting paid at all and having an easier way of dealing with that when employers take arbitrary and unreasonable and unfair deductions that are really hard on people that have having a hard time just living from paycheck to paycheck when they get all of their money. So that's one way of dealing with the fair wage deal. Now, the other thing that people are angry about at the local level, of course, are things like forcing people to work out in the heat when it's 105 and not having a water break, etc. Later on, I'm going to talk about ways that local governments might be able to accomplish more, not by ordinance, but by becoming activists in other ways, or by using other federal and state agencies to accomplish what they were trying to do. And OSHA is an underused agency in this regard. If you think that it's unsafe to be working in 105-degree weather, especially if the employer doesn't provide easy access to water, that might be an occasion for a general duty charge. Anybody can file a general duty charge. If I see workers who are being exposed to unsafe work conditions, I can call OSHA up. And the general duty clause is just a general statement that it's a little bit like tort law. If somebody is doing something that's dangerous and exposes people to harm, that could be a tort under the reasonable duty standard. It's very vague, but it comes in handy when you see things that don't have a specific regulation. The advantage of OSHA is that you don't have to wait for people to be hurt or killed. The fact that it's already exposed workers to a danger gives you the opportunity to initiate an OSHA charge. And I wonder if if local governments and communities or organizations couldn't use that idea a lot more effectively than perhaps trying to regulate it by ordinance at the local level. Okay. So what more effect does the preemption law have? Well, it's very broad. I've been studying this to figure out, is there anything that's not preempted that a local government could do? And the answer is, it's hard to imagine. I'm not going to say that it's impossible. It preempts anything in an area occupied by the labor code. So if you're talking about a topic that is addressed by the labor code, it's out of the question for local governments. There is a lot of stuff that's not occupied by the labor code. To give you an example, what about a wage transparency law that I'll be talking about later on in my checklist or my wish list? Okay, wage transparency, which requires employers to be more transparent about what their wage rates are. It's not occupied by the labor code. There could be a debate about that for sure. Okay. And one of the issues that we will have going forward is, what does it mean to be occupied or not occupied by the labor code? The other question is, does this exceed or conflict with state or federal law? Well, state law and federal law don't even address the subject of wage disclosure or transparency. So I'm not sure that the Death Star is as powerful as it is believed to be. There may be some things still at the margins that local governments can do. But again, my recommendation for for local governments is look for other ways aside from regulating by ordinance to have the impact that you want. Okay, next big thing on my list of things that happened, the business courts. Now, do business courts have anything to do with employment law? As you may have heard, we've created a whole new judicial system. It's a special set of courts, trial courts and appellate court, that will handle a limited range of so-called business disputes. Evidently, the legislature, for whatever reasons, decided that certain business disputes belong in a specialized court devoted exclusively to those kinds of disputes. Does this have anything to do with employment law? Now, one prediction I'm going to make is that this is going to be an awful lot like the Texas Texas Citizens Participation Protection Act. Remember this law that protected, retaliatory lawsuits, and how complicated that got to be because the language is very vague and we have lots of arguments about what that means. I'm predicting we're going to have a lot of trouble with the new business courts law insofar as what it means and what's covered. To the extent that it's an employment law topic, the main reason it's not going to apply to nearly any labor dispute will be the jurisdictional limit of a $5 million dispute. It's got to be worth $5 million. That doesn't include things like punitive damages, interest, etc. So we're talking about $5 million in actual damages. I doubt that there are going to be many employment disputes that will qualify as $5 million disputes, except for one that I've been thinking about. Wage and hour disputes that involve collective actions, any kind of a class action. I haven't seen that a lot in the state courts of Texas. Okay, they typically end up in the federal courts. It is the one kind of dispute that, depending on how you interpret the jurisdictional rules of the business courts, might somehow be affected by this. But I think the actual practical effect is going to be very, very limited, because when people bring these big class or collective actions, they tend to sue in federal court anyway. Okay. Next on my list, the Crown Act. This is one of the remarkable achievements of bipartisanship lately. There's not much that the Democrats and Republicans can agree on, and yet in Texas and elsewhere, they do agree on the idea of the Crown Act. So what is the Crown Act? It's a law that prohibits discrimination on the basis of hairstyle. I'm not going to say as much as I might about this, because I think its primary effect is going to be in the schools and not in the workplace. The purpose of the Crown Act is, I think, mainly to protect people of color who also have characteristics of hair that are associated with race. There are certain hot hairstyles that are particularly suitable for certain kinds of hair that are also associated with race. And there have been instances in which employers have arbitrarily said that certain hairstyles are inappropriate. And they've discharged people for having inappropriate hair when it was a hairstyle that I think was actually historically associated with race. An example would be what some people would call dreadlocks. I don't think that's really an appropriate name for it, but it's the idea that people think of when they want to think of a hairstyle associated with race. There are good hair dreadlocks, and there are not so good dreadlocks. If If it's something that is specifically associated with a texture of hair and is in fact protective of that texture or type of hair, it's going to be likely to be protected under the Crown Act. It protects a protective hairstyle that is historically associated with race. Only dispute that I've seen that has happened since the enactment of this law is a dispute by a student. I think it's right here in Harris County. And it's illustrative of the fact that this is still a not open license to have any hairstyle that you want. You know, not everything is historically associated with race. And you can start with something like dreadlocks and then turn it into something much more extreme. I don't think that the law will protect the employee under those circumstances. Could I have dreadlocks and then paint my hair purple? And I think the answer is no. The law doesn't protect people with purple hair. Next item on my list, child labor. Now, it would be easy to overlook this as something important because, you know, we don't see that many cases of, I won't say we don't see many cases of child labor. What I will say is we don't see a lot of enforcement actions of child labor. Child labor really is a problem, especially I think in restaurants, which sometimes misuse the child labor that they've got. The thing to remember about child labor is that a child can start working at the age of 14. You can have a 14-year-old child. But if you're operating a restaurant and you need people to stay late and you demand that your 14-year-old work late or that your 14-year-old is engaged in hazardous work, you could be violating both state and federal law. Now, what kind of work could be hazardous if you're a 14-year-old? I actually engaged in what in retrospect was illegal child labor when I was 14. I was selling programs outside a stadium, and I was in possession. It was the nature of the work. You couldn't avoid it. I had an apron, and I had hundreds of dollars of cash in my pockets. Now, just imagine walking around a big city with a sign on your head that says, I'm carrying hundreds of dollars of cash in my pockets, and I'm only 14, and I don't know any self-defense, okay? You're going to get mugged, which is exactly what happened to me. My point is that child labor at the age of 14 can be lawful, but a lot of employers make the mistake of then employing the child to do something that is hazardous or is after hours. So I will make a certain point that we have updated the enforcement laws of child labor in Texas. We've raised the penalty. It's much higher now. I think in the range of like $10,000. You can really get hit by a much more substantial fine now if you violate this law. And we've updated the enforcement scheme. We've created the new child labor tribunals, special tribunals to hear these cases. And I suspect that we won't see a lot of commotion because most of these cases are pretty small. The one place where we really have to keep our eyes at with respect to child labor is this. We have a lot of unaccompanied minors crossing the border. What happens to these minors when they cross the border and they don't have their families with them? Well, the first thing is that the federal authorities take custody of them because it's a federal matter, not a state matter, a federal matter. And so these children end up in the custody and control of immigration officers who don't know the first thing about children. That's where a lot of our trouble arises. We have people who are in charge of the children and they don't know nothing about children or child custody. People show up saying, I'll take that child. I got a good home for that child. The home happens to be a meat packing company in some other city. So we need to keep an eye on this and be ready to use these new child labor enforcement tools if we see any of that happening in Texas. Okay. Next item on my list, a new reporting requirement for all employers. Workplace violence. This has been something that's been on OSHA's radar for quite some time. most OSHA regulations deal with the kind of hazards the employer creates, but we live in it seems like work is getting crazier and crazier. Imagine being a flight attendant these days and all the workplace violence that you deal with passengers. I've seen it myself. It's only within the past couple of years that I've seen crazy stuff that passengers do. Most people don't realize this, but one of the most dangerous jobs that there is, if I ask my students, what is the most dangerous job there is? They'll say, oh, coal mining, oil drilling rigs, convenience store clerk. Very dangerous job is healthcare, working in an emergency room where they're, frequently bringing in people who've just been involved in violent conflict and they're still really in an excited state. They're on drugs. Frequently, that's the problem. They're high on drugs and they get very violent. So healthcare workers, especially in the emergency room, face much higher risks of violence than most people appreciate. So a couple of things about this. Number one, all employers now have a duty to report incidents of workplace violence. You may have thought, well, it was just some angry boyfriend who came in and beat up one of my employees. That's not an OSHA deal. It's not a typical workplace safety thing to report. Now it is. Regardless of whether it's reportable under OSHA, it is now reportable under Texas law, and the report that you make is to the Department of Public Safety, the DPS. Now, what happens if you didn't know that and you didn't make your report? Looking at the law, I didn't see that there was much consequence to a failure to make a report. But I would say that we're sort of getting warmed up with this new idea that workplace violence is a really big deal that we have to address. And step one is the reporting requirement. I suspect that a lot of employers won't be doing their reporting, but we're going to start to create a system. If I were imagining where this will lead, it will lead to the collection of data. I hope somebody is at home at DPS. They'll actually be receiving the data. They'll be digesting it. They'll be thinking about it. And that will be step two. Once we find out what kinds of violence there has been, the magnitude of it, where it most likely happens, and what sorts of things might we do to address the problem, what employers can do, maybe then we can take step two and start to engage in some better regulation with teeth. Right now, the regulation has no teeth at all. But, if you are a workplace, you're in charge of a workplace and you have an incident of workplace violence, it happens to the best of us these days. Remember, there is a reporting requirement and the report will go to DPS. If you're a healthcare facility, you actually have a duty to create a policy or a plan to address your workplace violence problems. Again, the law doesn't say exactly what that would look like. And as far as I can tell, there's no consequence in failing to create a plan. It's just step one. Step two, maybe we'll get there in a couple of years. Okay, I think that exhausts my limit or my list of things that happened in the legislature of today. I'll pass it back to Lewis in case he's got some comments.
Please, before, excuse me, a housekeeping thing before I forget. For those of you we're able to give Texas CLE credit, would you please put your name and Texas State Bar number in the chat box? You will be getting the course number later in the program. For those seeking SHRM credit, also in the chat box, please put your name, your email address, and your cell phone number so that we can make the arrangements for you to get your SHRM credit. My apologies. Very important thing. I wanted to get that in before I forgot it.
Yeah, no, appreciate it. That's a good one. Yeah, I was taking notes, and I have a few comments on some of them. Some of them not as much, but I really appreciate that exhaustive list, and appreciate the CLE credit. Always appreciate that. So I just wanted to start with one of the first comments you made about the dysfunction of the state and federal legislature, and that's how it got pushed to the cities. And just give a little bit of context to that, particularly in the state legislature, there have been bills filed session after session. In fact, it's usually somewhere around the range of 5 to 10 bills to either increase minimum wage, to provide some type of leave policy, and sometimes it's really bare minimum stuff like allow for leave policy so that parents can go to their kids' events at schools. And it's not even doesn't even have to be paid. It's just a volunteer, just so they won't have to get fired. None of those bills ever see the light of day. If you cannot get the associations, particularly the NFIB, the National Federation of Independent Businesses, or the Texas Association of Businesses, to fully endorse it, you can't even get a hearing. So just to provide some context on that, of why there was a push from some of the cities to try to look at some of this. And then to that point, the big premise for HB 2127, the so-called Death Star bill, whenever the testimony came out, the business associations really came back to pay leave policy and wages, which, as you pointed out, were already preempted. And I think it's maybe worth visiting that court case a little bit. And for context, you all may remember there were a few cities, Austin, San Antonio, and Dallas, that passed a paid sick policy in response to the fact that legislatures have really not addressed this. And every other jurisdiction across the United States, those have been held constitutional and separate and apart from wage law. The Austin court, which was on the verge of being voted out because there was a change in the elections. As you all know, we elect our judges in Texas. Hastily put together a decision that essentially said, you get paid for leave policy. So if you get paid for leave policy, it's a wage, and therefore it's preempted under the minimum wage statute in Texas. It was, in my opinion, and maybe the professor has thoughts on this, not the most well thought out decision. It felt a little hasty and not really well thought out. But it ended up being relied upon both in other courts in San Antonio and as well in the federal court. And that's how we ended up with no leave policies in place at the local level. And then it was used to justify the Death Star bill that was already preempted. So a little bit of frustration there. And then I will say, when it comes to wages, I think one of the things that we've advocated for that is maybe something that we'd love to get some traction on is that I think you're right in the sense that, not everyone, very few people are making, under 725. But there are jurisdictions where, particularly in the urban, right, Austin and Houston, where the cost of living is so much higher than in other parts of the state, right? And so it'd be really, we've always, asked for is a floor. It's like, no matter where you live, this should be the floor, and then allow some municipalities to go up from there if your cost of living is way above there, right? So the fight for 15 is the one that has gotten traction over the years. Fight for 15, particularly in places like Austin and Houston. So that's, I think, an appropriate use of the wage laws, is to provide, like, look, you can't go beneath this, but let's allow some variations, because we know that Amarillo, El Paso, Rio Grande Valley, Houston, and Austin all have very different circumstances. And then there's also the aspect of, as you mentioned, the deductions and whether that could be addressed. Particularly, we hear that in the service industry, with restaurant servers getting deducted or using their tips as a way to, they get their tips taken away to say, well, that's part of your wages, and so we only have to give a lower wage because you're going to make it up in tips. Also, as we know, farm laborers are exempted from a lot of the minimum wage laws, and that's where an area of exploitation is. Although I agree with you that the bigger issue is wage theft, particularly with those vulnerable populations. So just wanted to provide a little bit more, context of some of that. On the water breaks, the only thing I just wanted to add there is that I think you're right in the sense that this is something that probably shouldn't be addressed at the local level. This is kind of to me, a bare level fundamental work safety issue that probably should be addressed with OSHA on the federal level by regulations. And there was a letter that was submitted to the legislature. It was a little bit interesting in the legislature when it came to the debate about water breaks. They kept saying, well, it's already protected under federal law. And we would supply a letter from OSHA saying that no, there are guidelines, but there are no requirements, that you have to provide a water break, and there's no enforcement on this. And it was kind of dismissed and not really taken seriously. But I think Congressman Greg Casad, who comes from the labor movement, is really, he did an action. I think it was a fast, particularly to put pressure on the administration, the federal administration, to add this to the OSHA violations and make it. And and in Texas, obviously we saw the well over 100-degree weather that was continuous for the entire summer. It did seem to be a real issue in terms of the perception that not providing a water break to construction workers seems cruel. So I do think that we'll get some traction on that on the federal level, about some of those issues. That was the main thing. The only thing I wanted to add on HB 2127, and you obviously pointed out, we're talking about labor law, but for those that are following, it also did the same preemption, field preemption, for the finance code, the natural resources code, the agricultural code, and the property code, right? So that is when we're talking about payday lending, we're talking about sexually oriented businesses, we're talking about rental control, rental assistance, any type of environmental regulation around fracking. These are some things that have come up in the past. I will say that they grandfathered in the existing payday lending ordinances. And the premise was that there are about 40 to 45 jurisdictions across Texas that have laws on the books regulating payday lenders, particularly abusive payday lending. What we have found is that they find loopholes, right? And they also, as the professor pointed out, they'll move, right? They'll move across the city lines, they'll move across the county lines to the smaller city and then set up shop there. So unfortunately, with under 2127, there can be no new ordinances. So if they move across the county line or the city line, then that city cannot enact a new ordinance, nor can they modify the existing ordinance. So they find a loophole. You're regulating the interest rate, and then they come up with a new term or a new fee, a new cost, whatever it is. There won't be a way to regulate that if it's not already on the books. So that was some of the things we had to deal with there. I do think that one thing I wanted to also mention is when it comes to the Crown Act, that might be a model to look at. As you pointed out, it was bipartisan. Representative Bowers out of Dallas has championed this issue a couple of sessions and was able to get it done this session. The other one that got traction this session was the issue called Ban the Box, which is about criminal history in hiring and employment, and whether or not you can ask those questions. That bill got out of committee and got some traction for a statewide inaction, but didn't get across the finish line. And so maybe the Crown Act is the model to look at. Then now if cities can't get involved in these issues, that we think it should be statewide, and that was the number one complaint among the business industry, was they didn't want this patchwork of laws, that we should be looking at statewide reforms, and get those conversations going, and use their own language, that we should have a across the board approach to these issues. So those would be the two that I would look at. I would look at a floor for minimum wage that would allow for some local discretion, and ban the box, using the Crown Act as a model for statewide reporting. But those are just some of my thoughts I had on some of your comments, and I really appreciate your thoroughness in covering all the different bills that got passed this session.
Let me throw a question or two out to the two of you. It really kind of was motivated by some of your thoughts, Professor Carlson. What would you say to the argument that the economy itself, there are employers out there begging to fill seats in their companies, and some of it has to do with money, some of it has to do with quality of life issues. I mean, the Starbucks caffeinated organizing is a perfect example of that. It's not just about money that employers are looking for. is that just the natural market economics, we don't need to legislate something which is going to require more people to engage in handling charges, and we've got to fund those people with just natural economic forces will address the issue. And the other question I have is, we do have the wage and hour division that handles complaints about, if, for instance, people are tipped employees and they're having to give away part of their tips to the manager, violates Fair Labor Standards Act. We already have a procedure and process for that. So why do we need to encumber what we are, add to what we already have, or at least some would argue we already have?
Yeah, that's a real important question. And I can sympathize with the business side saying, look, employment law is already complicated enough. I often joke with my students, I can walk into any workplace in America and I can come up with at least 10 violations if I am there long enough. It's complicated. And I've often also observed that the most effective laws are the simplest. If you can keep it simple, people can more easily comply. I think a floor on wages can be really simple. Overtime gets complicated. The free and clear rule is really simple. I work X number of hours. You have to give me cash, at least this amount, for the number of hours I work so I can pay my rent, etc. And I do sympathize with employers, especially small employers, that feel oppressed by detailed rules and regulations. But I think at least the idea of a minimum wage to prevent this kind of wage theft is easy enough that I think employers could probably live with it. Most employers comply with this anyway. Most employers who want aren't violating these laws against underpayment of wages or deductions. Where you see it is the employers who just aren't honest people, okay, and they're the ones that are competing with the honest employers too. So I think that you could get a lot of benefit from having a higher floor on the wage, protected against deduction, free and clear, that would particularly deal with some really gross incidents of wage theft by employers that I don't think any of us would be defending. So that's number one. But yeah, and the other side of your comment about the complexity of the law, this is why it's better if we can achieve it to have a statewide law rather than multiple laws in every county. And I think employers would also tell you having a law in every state is complicated enough. So yeah, I'm also frequently frustrated with the fact that if I'm going to teach a topic about employment law, people ask me, what's the answer? And I say, well, there are probably 50 different answers to that question.
Luis?
Yeah, I think that's fair. I think one thing I would say is, a lot of times these laws have exemptions for the smaller companies, whether under 20 or under 50. I think that's one way to address the complexities. I'm a little less sympathetic with the giant corporations that have businesses all across the United States and across the world and navigate this stuff all the time. And they have, the resources, I think, to handle it. But I do sympathize with some of the very small mom and pop shops that may want to grow out a little bit. And so I think there's room for exceptions for that. The other thing I'll point out is that the frustration a little bit, one of the biggest testifiers at the legislature was a restaurant named the County Line. It's in my home county of El Paso. And they set up their restaurant literally on the county line between Texas and New Mexico. And that is their whole niche. It's like, oh, we're on the county line. We're both New Mexico, we're Texas. And then they go to the legislature and they say, oh my God, I can't deal with having to deal with two states. It's so hard. I don't know how to deal with this. It's so complicated. I was like, well, you chose to do that. That was where you wanted to be to make that a niche. So I'm a little bit less sympathetic with that type of situation, but fair is fair, and I get your point.
Well, thank you very much. I'm trying to keep an eye on the time too. Do you want to move on? I know, Luis, you did mention the ban the box legislation. That was something that was starting to get some traction when the legislature this past session didn't make it out. But is it not often the case? That's just the way it works in Texas. Is you kind of you get up there, you don't even make it out of committee or whatever, and then the next session you make a little more progress. In the session after that, you make a little more progress. Are there any other kinds of laws other than the ban the box that started to get some traction that impact the labor and employment arena in Texas that they were filed, just didn't make it out of committee or whatever, and never got voted on, that we might expect to see in the not too distant future?
The only one I'll point out, in addition to ban the box, was for the first time we passed paid parental leave for state employees. So obviously that just affects state employees, and it didn't impact universities or K through 12 state employees, but the agency employees it'll impact, and that was and also a bipartisan bill that was negotiated with Senator Nichols on the Senate side, and passed quickly and easily. I would say it was mainly just a question of how many weeks and how much to divide between fathers versus mothers and the parental leave. So one thing we would like to look at that we were hoping would get some traction is a bill that would allow for parental leave for private employers, where employers could pay, or employees could pay into a system, and then that would fund the parental leave program statewide. It was a little bit complicated. We initially had some support from the Federation of Independent Businesses. It looked like the Chairwoman Chin was interested, was going to give it a hearing, and then they kind of pulled out at the end. And we're hoping we can revive it again next session, because we think it may be a little bit complicated, but I think the big concern about how do we pay for it, how we deal with it, we address with a statewide fund and a way for companies to kind of pay into it and address it. So we're hoping that'll get some traction next session. We'll see. This might, parental leave, especially in light of the Dobbs decision, has gaining more traction. For those of you who aren't familiar, the Dobbs decision is the Supreme Court case that struck down abortion rights on the state level. And so with that, there has been increased concern about supporting families that will have, children and childcare. We know that there is a huge underfunding of daycare facilities in Texas and nationwide, and the funding for them that was coming out of the pandemic, the ARPA funding has dried out for the daycare facilities, and there's a number of daycare facilities that are about to go out of business. So finding the childcare for your child is increasingly becoming a bigger issue. And there's a lot of parents that need that leave to take care of their little ones. So that's something we're looking at. I don't know if you have any thoughts on that, Professor.
I could add a couple of points about this. Since we're in an era where we really need to figure out a way of achieving bipartisanship and appealing to the other side, that especially fiscally conservative politicians, what can we say about better publicly funded childcare that would make them take a greater interest? There is a huge amount of data that societies that invest in their children grow and develop much better than societies that don't. Education, every country that has invested heavily in education has achieved much higher growth rates than those that don't. So what's the problem with preschool support? The thing is that people don't appreciate the economic benefits to the whole economy and society when you make it possible for people to go to work. And this is especially true of people for whom childcare is way too expensive, considering the wage rate that they're earning at the restaurant or the factory, right? Wealthy people, middle-class people, affluent people can afford it, but it's a really difficult decision for somebody who's earning a much lower wage rate, childcare doesn't make any sense. I remember talking with a woman who was paying as much in childcare as she was earning in her job. Why don't you stay home and take care of the child then? Okay. So if you want people to be able to work productively without worrying so much about their kids and trying to make this happen, you have to provide for quality preschool care, which will lead to better educational results and will allow people to be good employees. And this is the sort of thing that makes economies grow. But I think we need to start making that connection with the public as a whole to make them appreciate that this is an area where money is well spent. People worry about welfare, paying people not to work. That's the argument that you hear about any new social welfare benefit. How about paying money to help people go to work, to make it possible for people to work, and to also jumpstart education for young children?
All great philosophical questions. We could have a whole nother program on this, but it's in the interest of trying to cover the other topics, which I know you both have some great things to say on. You touch base on the things that haven't made it, but have started to get some traction. And I think you've alluded, Professor Carlson, to one or maybe two, kind of wish list things for the future that you see maybe percolating, that we might see stuff entered in the next legislative session.
Yeah, I have a long wish list, so I'm trying to keep it confined today. And I'm trying to address things that are mainly things that would be done at the state level. Talk about my federal wish list, it's bigger. And like a lot of professors, I'm always thinking about new laws rather than less law. Okay.
That's called business development, isn't it?
Yeah. So some of my recommendations, I think, could be sold to employers. And I don't know that the first item on my list is one that is really appropriate for this audience because it's mainly just for public employees, okay? But it's a start. And we may have some members of the audience who are working for with or they are public employers. Our Whistleblower Act is a mess. And I could say a lot about it, but one thing is that we protect external whistleblowers, but we don't protect internal whistleblowers. And some states have realized that this is backwards. You should do it the other way around. You need to be able to send a signal to your employees. If you are an employer, if I'm an employer, I want to send the following signal to my employees. If you see something going on that's bad, come to me and tell me so I can fix it. Don't go straight to the authorities and cause a major SEC investigation or something like that when I haven't had a chance to even know what was going on. Come to me. I'd like to be able to say that. But under Texas law as it is, if I'm a lawyer advising an employee, here's what I've got to tell the employee. Don't tell the employer a thing. Don't tell them. Because if you tell them that you've seen something going wrong, that just gives them a chance to retaliate against you before you can reach the phone and call the external authorities. And if that happens, you won't be protected. So we have it backwards. We protect people who are just reaching for the phone first opportunity they get. And we're not protecting the ideal employee who tries to deal with the employer internally before we go external. That's backwards. Okay. Second thing, we have a problem with non-subscribers in Texas. Okay, these are employers who opt out of the workers' compensation system. And there are two major problems I see with this. First of all, I can understand why, if you're an employer, you would like to adopt this option because it does seem less expensive than workers' compensation. But the reasons that it's less expensive are somewhat troubling. One of the reasons is this. I don't have to tell my employees how my insurance coverage compares with workers' compensation. There's no rule that tells an employer that it has to provide insurance at all. And if I do, and if I tell my employees I'm providing substitute insurance, maybe it's really bad insurance. There's no requirement of disclosure by the employer. So I think if the employer wants to go the non-subscription route, and if it's going to provide a alternative insurance scheme to protect it from tort liability, there's got to be some kind of a disclosure scheme so that an employee can intelligently compare workers' compensation versus this so-called insurance plan over here. And then I have an option either to accept my employer's plan or stick with workers' compensation. The other reason why opting out can be so financially favorable to the employer is that the Texas courts are saying that non-subscribers are not covered by the anti-retaliation rule. If somebody files a claim for a work-related injury or illness, I can retaliate against them. I can fire them on the spot, and I haven't violated any law. That puts non-subscribers at a huge advantage against employers who are still in the workers' compensation system. And if we aren't careful, we're going to create a scheme in which it's almost a no-brainer for employers. Why am I subscribing to workers' compensation when I can save so much money by opting out?
Professor Carlson, let me do the devil's advocate here since it's come to mind. Most of these opt-out plans that I have, I'm not an ERISA lawyer, but I when I was an advocate, I did do the discrimination, anti-retaliation stuff, is that most of the opt-out plans to get the benefit of ERISA preemption created ERISA plans. And ERISA itself has an anti-retaliatory provision. So doesn't that narrow the field of employees who don't have an avenue to complain about a retaliatory discharge or discriminatory discharge?
Yes, with two qualifications. Number one, ERISA has limited remedies. If you can sue under our Texas law, you'd have broader remedies. Secondly, there are still ways an employer can deal with this. There are ways that you can avoid creating an ERISA plan. For example, you could just go naked, as they say, and accept tort liability, but with an arbitration clause. So you are right. If we, for the most part, if we create an insurance alternative to workers' compensation, it's very likely to be covered by ERISA unless we find some way around that, which I think some employers will try to do. If an employee and I have my choice between an ERISA remedy versus the Workers' Compensation Act, I think I definitely prefer the Workers' Compensation Act. Okay. So next on my list is something I've already talked about, which is wage theft and the importance of an effective minimum wage law. We've talked about statewide breaks for very hot days and the need for water. Again, I think an underutilized tool is the OSHA General Duty Clause. Let me talk a little bit about the ban the box idea, because that was something that evidently did get some traction. So let me say a few words about that. The purpose of the ban the box rule is to deal with this impending problem that we have, in which something like 20 million Americans have become unemployable. They're unemployable in any work that they could reasonably do because they have a criminal background. And we're not just talking about people who committed serious crimes and just got out of jail recently. Even if we're talking about a possession of marijuana charge that goes back to when you were 18 or 19 years old, a DUI that goes back to when you were 18 or 19 years old, that's still on your record. And the problem that we're facing is that employers can now very, very cheaply do a background search that turns up everything. So in the old days, it was impossible for an employer to do an exhaustive criminal background check. The best we could do is ask people a question on the application form. And if later we found out that they were dishonest and not disclosing something, we'll fire them for that. But you can't go down to the courthouse in the old days to do a manual search And if you did, you wouldn't be doing every county in the United States. That's changed hugely. I actually experimented with this because I was doing some research in this area. How much can you find out? So I bought a 1-month subscription to a background checking service. They had it divided into gold, silver, platinum, bronze. I'm cheap, so I bought the bronze plan. It allowed me to search anybody's background for an entire month. And if I'd been an employer, then I could have searched everybody's background for 1 month for a fairly reasonable fee. I resisted temptation. The only person that I searched was myself because I know what's true and what's not. Couple of things I learned from this. It's really, really easy and not expensive. So employers are really getting this data. I also learned it's not very reliable, but that's a problem for another day. The thing is, we have a lot of people who just have that black mark on their record. We have done one thing, which is to allow this, expungement process. But don't be fooled in thinking that expungement alone is the solution. Because even if you have expungement, the record is still there. And the thing that worries me is that a lot of employers looking at people's records, the employer's only got a limited amount of information about its candidates. It's got a lot of people for very few jobs. It's very easy when you're an employer making decisions about 1,000 candidates to arbitrarily reject everybody with one of those marks, even if it's marijuana possession when they were 19 years old. So I would like clearer laws that say, number one, if my offense was expunged, I don't have to truthfully answer a question, have I ever been arrested or convicted? I can just assume that that never happened. I have the right under Texas law to treat that as something that never happened when I answer an application question. Secondly, I would like to at least explore some limits on the kind of information that I have to disclose or that is searchable by an employer or usable by an employer. Number one, a time limit. Right now, there's no time limit at all. If your offense happened when you were a teenager 30 years ago, it's still on the internet and it's still discoverable by an employer. I think there ought to be a time limit at the very least. And secondly, we need to start thinking about at least some types of offenses that shouldn't be discoverable. Possession of marijuana, I think that's where I would start because it's the kind of offense that we're all thinking a little bit differently about these days. If you've got somebody who used marijuana in college, is that somebody that you would never hire? And I think some employers are just automatically rejecting people who've got that spot on their record. It's also hugely racially discriminatory. I looked at some statistics that would shock you about the different ways that we treat people with respect to possession of marijuana, depending on whether they are white or of color. The conviction rates for people of color for possession of marijuana are sky higher than they are for white people. It just really shocked me. So if you want to do something about racial justice, this is one place that you could start. How do we deal with these old marijuana possession records? So that is my wish list.
Luis, what about your wish list?
Yeah, no, I like it. So one of the things that we are advocating for, well, let me just start with some of our broader advocacy. We are going to be launching a campaign called the People's Budget. And the idea of the People's Budget is that every time we go in a session, that we get the revenue estimate from the comptroller, and they say, this is how much money you have. And then it all gets divided into pies, right? And we never look at any of the revenue side. And so we're kind of stuck with whatever the pie is. Now, obviously we had a big surplus this session, but when the, economy hits, there's a recession of any sort, we are increasingly becoming reliant on sales tax, and especially with all the cuts that are happening on the property tax. So we like to reimagine our approach and make it more progressive and less regressive by imagining what we could do with a bigger pie. what we could do with additional revenue, and particularly we weren't spending $5.1 billion on border security, what we could do for childcare facilities, what we could do for workers, what we could do on the education side, what we could do for teachers. So that's a big pie in the sky discussion. That is going to take a movement. That is going to take some grassroots hard work, getting into communities and talking with communities. That's the ultimate pie in the sky vision. But more succinctly for next session, we think we really need to start talking about teacher pay. The issue of teachers has risen to a real crisis, in our opinion, with after the pandemic, with the number of teachers that were leaving the industry, the number of teachers that are teaching outside of their expertise. And I think there's a couple of approaches to that. One is increasing the basic allotment. In 2019, we tied the basic allotment, which is the base unit of school funding. If you increase the basic allotment funding, you increase all the other parts of the school finance system, including the teacher pay. So that is a way to rise all boats and improve our education system across the board. The other one is a little bit more controversial, and that's talking about collective bargaining agreement and bringing that into the discussion for teachers. That's a tougher sell, we know, but we think it's time to start having those conversations. If we really want to support our teachers, we got to give them better tools to fight for their rights. And so that's a bigger discussion, but I think that's one thing we're interested in talking about. And then the other one, as I mentioned before, which is the parental leave for private employers, and whether we can come up with a workable solution there that comes up with a way for employers to be able to pay into a system and come up with a solution there. And then we talked also about childcare facilities. I think that's another issue that we have to talk about. How do we raise wages, improve conditions, and keep a functioning childcare facilities going in Texas as more and more of these facilities are struggling. So those are a few of those issues. We work on a whole range of issues. One of our big victories this session was actually related to food access, which is an issue for workers. During the pandemic, you all may have seen that picture of San Antonio with thousands upon thousands of cars waiting in line at the food pantry. Well, prior to this session, we had a very restrictive process for accessing SNAP, where if you owned a car and that car was worth more than, I think it was more than $14,000 or $15,000, you were ineligible for SNAP benefits. And you had a second car that was worth more than, I believe it was $8,000, you are also ineligible for SNAP benefits, while also having work requirements, right? So if you had a functional car to get to work, you couldn't get the SNAP benefits. But if you couldn't get to work, then you also were denied your SNAP benefits. So we updated those limits this session. We wanted to tie it to the inflationary index. But on the Senate side, they did not want to do that, so they raised it to a specific amount, and it was passed. So it's a more reasonable number at about $20 some thousand for their first car and $14,000-15,000 for the second car. It's not perfect, but it'll definitely increase the number of people who can access those SNAP benefits. We would love to build on that legislation next session. And talk about, the bureaucratic process of having people have to renew so frequently, and whether we could do what we did on the Medicaid rolls, which is allow for continuous care so that we don't have to burden the state employees and the recipients of having to renew their eligibility every month, every few months, and allow for that continuous care. And so those are a few of the things we're looking at. But I like the professor's ideas as well, and very interested in keeping those conversations going.
I want to open up the conversation. This has been great. I knew I was going to be able to sit back and just let you two talk. But before we see if any of the attendees have any questions, I want to remind those seeking SHRM credit that to please put your name, your email address, and cell phone, and indicate that you do want SHRM credit in the chat box. For those seeking CLE credits from the State Bar of Texas, you need to do so on the State Bar website. The course number I've placed in the chat box, but I will repeat it here. It is 174-206-688. Again, 174-206-688. Unfortunately, we're not able to go through the process to try to get other state credits. But if you are licensed in another state, perhaps you can use the fact that it's been certified in the state of Texas for your other jurisdictions. If you have a question, please put it in the chat box, and I'll raise it with our incredible panelists. And while I'm waiting for that, I've actually got one or two. Is that Professor Carlson? You've mentioned a couple of times, and I think this is true. OSHA is probably an underutilized agency. And when you're underutilized, you don't get funding from Congress. That's the reality. That's the yin and yang of being a federal agency in a way. But do you have any thoughts about why you think it is so underutilized? I mean, we're hearing about OSHA. We hear, if you listen to the radio or watch TV, you do hear about it a lot more now than you did in the past. But and the general duty clause is very fuzzy. It's got a lot of room for persuasive arguments. So, but I agree with you. I tend to think it's underutilized. Why do you think that is?
Probably because it is understaffed, number one. To make it more useful, we'd have to employ more OSHA inspectors. Number two, I think OSHA is just an agency that people typically don't think of. There is a widely held belief that if OSHA doesn't have a rule prohibiting something, it's okay. But that's not entirely true. The people who need to be using it, of course, are the individual workers who don't even know that there is an OSHA. So I think there needs to be more support. Labor organizations can do this. Community organizations can do this. Local governments perhaps can do this, because anybody can file the charge, initiate it. Sometimes OSHA needs to be pushed. There needs to be some reason why they feel like they should take up this case when they have so many other cases that they're dealing with. So local governments perhaps can be effective in pushing OSHA to make OSHA appreciate that this is something that is important to a lot of people. And this heat wave problem is something, I think we really need to start getting a handle on.
Another question that popped into my mind, again, it kind of harkens back to another one I asked earlier, is that with respect to ban the box legislation, the EEOC certainly has been pretty aggressive over the last 5, 8, 10 years with respect to the abuse of, in its eyes, of employers seeking particularly criminal arrest. Mm-hmm. Almost always will get an employer in trouble. First time, every time, no matter the offense for which arrest relates. But even with respect to convictions, how recent was it? What was the nature of the offense? Is it reasonably related to the job duties and expectations you might reasonably have? We've already got a framework in place for a lot of that stuff. Why do we need separate legislation?
Well, first of all those EEOC regulations are illusory. EEOC has them.
We lawyers say, thank God, that's business development.
Yeah, but they're not enforceable. I hate to say this because it disturbs me. The EEOC has, as far as I know, they've never won a case in trying to enforce these. And it's a long-winded explanation for why these regulations are probably beyond the EEOC's authority. I'm not going to go there today, and I urge everyone to try to comply with them anyway, because they're good rules, but they have no teeth. And the reason is, I think, way outside the restrictions of our limited program here. We do need something with teeth and that addresses the system better than the EEOC regulations can.
Well, I'm looking at the clock and we're at 1:15. The time has just flown by. I want to thank you both for superb presentations. If either of you have any closing thoughts that you'd like to put out there, I'd like to give you each an opportunity to do so. Professor Carlson?
Well, just to remind us all of a sort of ongoing theme here is the importance of finding some new bipartisanship, some way of bridging the difference and looking for the ways that we all want the workplace to be a better, happier, and safer place.
Luis.
I'll start with my career started, and that's in the electoral side, the voting side. If we really want to get some of these things done and have those conversations, we're going to need more electoral, political participation across the state to really hold some of these electeds accountable. As I said, these conversations that we're having today are not really happening at the legislative level. The conversations are if you don't even get a hearing, you're not having a conversation. And if we really want to start moving the ball on some of these things, we really need to hold some of our electeds accountable, and letting them know that worker rights are human rights, and that these are important issues to you and your families. And that will be the only way we can start, moving the ball on these on even the incremental level. So I appreciate this opportunity to talk. I think it was I learned a lot from you, Professor, and I appreciate you sharing your knowledge and inviting me. And I thank you for letting me try to fill the shoes of the great Rick Levy. But it was a real honor to be here.
Well, Luis, let us thank you for being willing, literally at the 11th hour, to jump in and bring your expertise. It's obvious that you've got an incredible background and you're a wealth of knowledge. And I'm personally glad we've gotten to know you. I'll offline give you a little personal story about walking a picket line with my dad, who's a teacher in Western Pennsylvania. Professor Carlson, again, we thank you for your repeated support for our organization. And with that, I'll turn it over to our noble president, Mr. Mickey Brock, for any final.
I can't talk.
Mickey, yeah, there you go. Just keep your phone microphone on, I think. We can't hear you.
Can you hear me?
Yes, can now.
Thank you so much. I thought this was a really good discussion, and kudos to both. And just thanks to Lewis for filling in on such short notice. Did a great job. And Professor Carlson, you're just a wealth of knowledge. So thanks, everyone. Thanks for all of you who attended. Thanks to Emily and Bernadette for their technical help in getting this together. And we'll look forward to another program in November from us. It's probably going to be around mediation, and we're working on the details for that. So we'll have to have Professor Carlson and Lewis here again for another continuation of this discussion. It was good. Thank you, everyone.
Have a great day.
Thanks to Chip for Pat for pulling this together. Great job.